Hello and welcome to the United States Patent and Trademark Office webinar series for experienced practitioners. My name is Marisa Terrell and I'm an attorney in the Trademarks Customer Outreach Office. I'm pleased to serve as your host today. Now, no doubt, as an experienced practitioner, you're quite familiar with the USPTO's Acceptable Identification of Goods and Services Manual. But how much do you really know about the NICE classification, the controlling classification system used by the United States? In today's webinar, two of our experts in the Office of Trademark Classification Policy and Practice will discuss recent changes to the NICE classification and how those changes impact U.S. identification policy and practice. Before I introduce our experts, though, I'd like to share just a few announcements with you. Today's session will be recorded, and you will have access to the recording in about 3 weeks or so by visiting our website, uspto.gov. Today's slide deck will be emailed to you via Eventbrite after today's presentation around 3:30 p.m. Eastern Time. You can also find a link to the slides and the handout in the chat window. And where is the chat window? Well, you can find the chat window at the bottom right of the screen. A quick tip about our chat box. Any hyperlinks that you find there are live, so you should be able to simply click on them to access any information. Now, time permitting, we're going to open up the discussion for questions at the end of the presentation. You can submit your questions to us today by using your chat window. And you may notice that that chat feature is turned off right now during the announcements, but it'll be turned on when we start the presentation soon. For your convenience, captioning for today's presentation is available, and you can access that captioning in two ways. Go ahead and check the chat box for a live link, or you can also click on the closed captioning icon. You'll see a text bubble with the letters CC on the bottom left. And finally, good news, we've been approved for 1.5 hours of CLE credit in Virginia. So we'll be sure to forward the CLE documentation to you, or if you're on our attendee list. The documentation will include instructions on how you can apply for CLE credit outside of Virginia. Now, if you have additional questions about the CLE process, please email us at tmwebinar@uspto.gov. That email again is tmwebinar@uspto.gov. And that's it for my announcements. So now let me introduce you to our expert presenters from the Trademark Classification Policy and Practice Office. Our first expert presenter is Mary Munson-Ott. Mary is a staff attorney in the Trademark Classification Policy and Practice Unit. And in her role since 2009, Mary develops identification and classification policy and also provides guidance on identification and classification practice, including identification and classification of new technologies. Mary has significant experience representing the USPTO at the NICE Classifications Committee of Experts meeting at the World Intellectual Property Organization headquarters. She's also regularly trains and mentors newer attorneys on ID class practice. Mary is a graduate of the University of Wisconsin-Madison and Tulane University School of Law. Our second expert presenter is Amy Kelly. Amy has worked as a staff attorney in the Trademark Classification Policy and Practice Unit for 9 years. And before assuming her current position, Amy worked as in-house IP counsel for Payless Shoe Source and as counsel for Shook, Hardy & Bacon, LLP in Kansas City. Outside of the office, Amy is an active community volunteer and has been a member of the board of directors of the Boys and Girls Club of Lawrence, Kansas, among many other organizations. Now, at this time, I'm going to go ahead and turn the program over to our presenters, Mary Munson-Ott and Amy Kelly.
Good afternoon and welcome, and thank you so much for that introduction. Thanks everyone for joining us. As Marisa said, today we are going to give you an update on changes to U.S. ID and classification practice. These changes result from the NICE classification 12th edition, version 2024, We call that NEAS 12-2024 for short. And all of these changes went into effect on January 1 of this year. So to get started, we first want to give a short introduction or perhaps a reintroduction to the NEAS classification, including an insider's view on why it's important and its impact on U.S. ID policy. We will then describe the most significant changes under NEAS 12-2024. Last year, there were over 500 proposals from 40 different national offices to change the NEAS classification, and the Committee of Experts considered and voted on each one. The discussions that take place at the Committee of Experts meetings influence U.S. policy, and the committee's decisions have a direct impact on U.S. classification practice. And we want to highlight the key changes for you today. We'll also share practice tips, but let's kick off this hour with the key takeaways from the webinar. So if you only remember one thing from this webinar, we want it to be this. First, the NEAS classification is a guide for classification only. Any specificity requirements that are based on the NEAS classification are for the purposes of limiting the ID to a single class. Also, the NEAS classification is mandatory. Members of the NEAS agreement are required by international treaty to apply it when registering marks. Finally, the NEAS classification guidance is incorporated into the US ID manual. When new IDs are added to the manual, the administrator for trademark classification policy, she deliberates with her staff and decides what class is the right class. We then designate the class in the manual to take out the guesswork and in order to help applicants prepare their applications. Like I said, if you only remember one thing from this webinar, we would like for it to be these key points.
Okay, and again, thank you very much for joining us on this webinar. This webinar was promoted as one for experienced practitioners. Actually, really, it's for anyone who has an interest in the NEAS classification or in particular to updates to the NEAS classification that, as Mary said, were effective this past January. But to better understand who you are and maybe to help us fine tune future webinars on the NEAS classification, we want you to answer this poll. How well do you think you know the NEAS classification? What's your level of familiarity? Here's a hint. There are no wrong answers. So please check how you feel yourself in relationship to the NEAS classification. You getting some answers in? Are you recording them? Are you a beginner? Is this new to you? You're curious about NEAS? You kind of know what it is. You're an intermediate. You think you're good. You're like, oh yeah, I got this. I totally got this. And that you're an advanced. Okay. Do we have our answers? Jay, have you turned off the poll? Where are we? The poll has ended. Da, da, da. Okay, some pretty good answers, some honest answers. Some people think they're beginners. Welcome aboard. Intermediates, that's where most of us landed, fine. And advanced, good on you. Stand up and be counted for you that you know what you're talking about when it comes to NEAS. Good for you. So anyway, thank you very much. All right, back to you, Mary.
All right, thank you, Amy. And it's great to get a feel of the knowledge level and experience level with the NEAS classification. It seems that we do have many who are fairly experienced and knowledgeable, so we can move a bit faster through these next slides. So the NEAS classification is a system that creates categories of goods and services. It organizes those categories by number, and then it groups similar goods into the same category and similar services into the same category. So just as an example, because we do have some beginners on board, all types of vehicles will be in the same class. That's class 12. And all types of education service activities are in the same class. That's class 41. The Nice classification is part of an international treaty called the Nice Agreement, which is administered by the World Intellectual Property Organization, or WIPO. Today, more than 90 countries have signed on, and more than 60 additional countries voluntarily apply the Nice classification when registering marks. This widespread use has a number of advantages. The primary advantage is that it promotes consistency among national trademark offices, making it easier for them to organize and administer the trademark applications and registrations. This consistency also makes it easier for trademark owners to search records for potential conflicts, because classification actually shrinks the universe of potential conflicts to the assigned class and the related classes. So let's find out more about the Nice classification. It has three parts. The first part is the general remarks, which lays out the basic classification principles. It tells us that goods are generally classified according to function, and services are classified according to the nature of the activity. It also tells us that we need to look at the other parts of the Nice classification in order to figure out which class is the right one. There are 45 class headings in all, 34 for goods and 11 for services. The class headings use broad wording to generally describe the categories of goods and services. And then the explanatory notes give even more detail. They also give examples of goods and services that are included and excluded from each class. Finally, the alphabetical list. It includes more than 10,000 goods and services, and each item in the alphabetical list has a unique basic number. So you'll very often see the alphabetical list terms referred to by basic number. Although some national offices accept the exact wording in the alphabetical list as IDs, the USPTO most often does not. We generally require more detailed IDs. We require those details to enable complete examination of trademark applications. Now, I'll talk a little bit more about the classification uh, analysis, how we go through the process. So classification is methodical under the general remarks. To classify any goods or services, we first have to determine their nature or their purpose. We look at dictionary definitions and we look at how the goods or services appear in the marketplace. Then we look for any mention of that function or nature or purpose in the different parts of the Nice classification. When there is no mention, we try to find some type of analogy to justify the class. When that doesn't work, or when the goods and services seem to straddle multiple classes, we look back to the general remarks for direction on what to do next and what other criteria we can consider. Now, there are circumstances when the Nice classification provides no guidance, or when there seems to be more than one reasonable approach to classification. Under those circumstances, national offices might adopt certain practices to fill in the blanks, and sometimes they develop different and conflicting classification practices. The USPTO makes an effort to identify and raise those conflicts at the annual Committee of Experts meetings in the form of proposals to amend the Nice classification. Amy's going to talk more about that process. Now, although the NEIS classification is a guide for classification only, it has an important impact on U.S. policy. The NEIS classification is the foundation of U.S. ID policy. It establishes the minimum that is needed in order to limit the ID to a single class. Then the USPTO often builds on top of that foundation, often requiring even more specificity to enable complete examination of the mark. So let's take a simple example that illustrates this idea. Let's take publications. Now that certainly is a category of goods and services, but that term is considered overbroad under the NEIS classification because it includes goods in class 9 and class 16 and also services in class 41. So you have to indicate the format. You might indicate downloadable, printed, or online non-downloadable. You indicate the format to lay the foundation and limit the ID to a single class. But then the USPTO builds on top of that foundation. We require you to specify the type of publication, like book or magazine, and also the subject matter of the publication. These requirements are U.S. specificity requirements that help the examiner make decisions about statutory refusals like likelihood of confusion and also descriptiveness refusals. Now, before I pass to Amy, let's take a quick look at the NEIS classification on WIPO's website. You can find the website by clicking on the link at the bottom of the slide. And I just want to take a few minutes to show you a couple features that I think are useful. So first, looking at the drop-down menus on the left side, we can make sure that the correct edition and version are selected. So here we're looking at NEIS 12, 2024, but notice that you can select older editions. And you can even select the version that goes into effect on January 1, 2025. Now, looking at the tabs on top, there are tabs for each of the three parts that I mentioned earlier, the general remarks and class headings. You can take a look at the alphabetical list in alphabetical order and also in class order. Now, you can also use this website to view the changes to each class by clicking on the Modifications tab and then selecting a particular class. So just as an example, if you click on Class 16, you can see that there were additions, deletions, and changes made to the alphabetical list in that particular class under NEIS 12, 2024. Now let's go back to the Classes tab. We're still in class 16 with the paper and the printed matter and the office requisites. The other thing I wanted to show you is these little gray boxes with the lowercase I inside. These are called information files, and these are developed by WIPO, and they often ask for input from the committee of experts when developing them. You can find them on the left side of the class numbers and also to the left of certain goods and services in the alphabetical list. Now, when you click on the box next to the class number, you'll see a general description of the contents of the class, and it's in narrative form, and it's often helpful because in this narrative form, they can do more comparing and contrasting. Now, let's go ahead and close that window and click on the little I next to a certain type of goods. How about adhesive tapes for stationery or household purposes? That's the first one we see, so let's just grab it. When you click on that box, you'll see a definition of the term and also an explanation of why it is in a particular class. You'll also see cross-references to similar goods or services in the same class, and also similar goods or services in different classes, and an explanation of why that may be the case. So these information files very often memorialize discussions that have taken place at the Committee of Experts meetings when the committee, and they explain why the committee decided to adopt certain terms. They can be really, really helpful for making connections between terms in the list and also for understanding the big picture. So that's all I have for the NEIS classification right now. Amy is going to give you more information on the procedures that the Committee of Experts use for amending it.
Thanks, Mary, for setting the stage of how the NEIS classification is structured and how it's used. But before we jump into how changes to the NEIS classification are made, a quick insight into the USPTO office may provide some context for you. Okay, so within the USPTO, now I'm talking about the trademark side, you have various divisions and business units, such as trademark operations. That would encompass the examining corps. There's trademark administration, for example. They provide the underbelly services for the office, the IT support, workforce programs, e-filing services, and things like that. And another one is Legal Policy Office. This is the division where Mary and I work, and within that section, there's a business unit that's called Identification and Classification, or ID Class for short. The ID Class office, and there are 12 of us in that office, are responsible for developing and implementing U.S. identification and classification policy. So one of our biggest tasks, and one that we devote time to all year round, is the NEIS agreement, specifically the NEIS Committee of Experts. Now, as Mary said earlier, there are about 90 countries that are members to the NEIS agreement, and each member country to that agreement is represented in the Committee of Experts. This committee meets every year, usually late April, early May, at the United Nations in Geneva, Switzerland. WIPO, again, the World Intellectual Property Organization, is the host. And it's a week-long meeting to discuss and vote on suggested changes to that NEIS classification. Any member country that is a party to the NEIS agreement may submit proposals for consideration by the other members of the committee, following, of course, agreed upon procedures for doing so. These proposals, which we call NEIS proposals, clever, huh? NEIS proposals, consist of the addition of new goods and services to the NEIS alphabetical list, the deletion of goods and services from the NEIS alphabetical list, or any modifications to the wording within the alphabetical list, or the class headings, or the explanatory notes, or even the general remarks. Currently, these NEIS proposals are uploaded into an electronic form, on the WIPO website. And once there, they are commented on, modified, compiled, and put into further discussion for voting at the next Committee of Experts meeting. Now, the slide you're looking at right now, this is a rough timeline for those NEIS proposals. They must be uploaded by the end of October, and all member countries may or may not comment on those proposals. And they have until the end of December to do so. Then comments to the comments, that is, those who made proposals, may respond to the comments to their proposals, and they may do that by the end of January. The meeting itself then is held later that spring. Just in case for those who may be unclear, the World Intellectual Property Organization is one of the 15 specialized agencies within the United Nations. WIPO was created to promote and to protect intellectual property across the world by with cooperating countries and with different international organizations. The International Bureau, the IB often we'll call it, within WIPO manages those activities. Believe it or not, as Mary mentioned, each meeting, each year, there are usually 400 to 500 proposals to add, delete, revise, improve the NIS agreement. Because these proposals are setting or sculpting or impacting international policy, these NEIS proposals are considered very, very carefully. Now, after the Committee of Experts meeting in Geneva, WIPO issues a final report of everything that transpired at the meeting. Of course, member countries get to review it, make sure it's accurate and reflects all the decisions that were made at the Committee of Experts meeting that year. With literally hundreds of entries, it takes many eyes to ensure that everything's been recorded correctly. After the final report is issued, we in ID class start to incorporate those changes into the ID manual. We call this NEIS implementation. While we comply with classification, the various ways we may word the IDs, all the synonyms and the related entries and things like that, may also be impacted by NEIS implementation. It's going to be like a bunch of dominoes. This one impacts this, and if you change that, then that puts these into questions, and you have to kind of look at all of those. It requires that we try to identify and resolve all of those direct or indirect touches to the ID manual made by virtue of the Committee of Experts decision. These annual revisions to the NEIS agreement are published electronically and are entered into force January 1st of each year. As Mary told you, these are referred to as versions, right? So the one that went into effect this past January is NEIS 12, 2024. But there's more. Okay, as part of NEIS implementation, along with amending the ID manual, there are many additional components to complete, such as posting notices in the Code of Federal Regulations or creating and amending USPTO internal and external resources. Posting such as the guidance for users that you may find on the USPTO website, all the hyperlinks that exist in the intranet and internet, and lots of training. NEIS implementation is a significant effort that requires participation from all of the ID class staff. Now, perhaps some of you have already picked up on this already, but note that NEIS implementation prepares the ID manual and all the ancillary resources to go live January 1st. Which at the same time, we're back in that NEIS proposal cycle of making proposals and uploading them to the WIPO website by the end of October, commenting on by the end of December, blah, blah, blah. That cycle goes on and on and on and on. Now, before we move on, let's take a quick knowledge check to see what we've learned so far. Okay, so here we go, knowledge check. NEIS classification is a guide for classification, mandatory for U.S. registration, generally incorporated into the manual, or all of the above. All right. Giving you a little bit of time to think about it. Not altogether sure. Didn't know there was going to be a test. Didn't know, but there is. Just a few more seconds. This isn't hard. This one was kind of a gimme. Okay. How are we on time? Jay, our expert poll taker. Dun, da, da, da. All right. So a significant majority of those who answered said all of the above. That would be correct. The answer to that question is all of the above. The NEIS classification is a guide for classification only. It's mandatory. It's incorporated into the manual. So well done. Glad you're staying with us.
Thanks, Amy. Absolutely. Well, those are the key takeaways that we wanted for you to remember. So thank you. Thank you all for taking the knowledge check. And let's move on to the key changes under the NEIS 12 2024. So as we mentioned, there were over 500 proposals as part of the 33rd session of the Committee of Experts. And there were many overlapping proposals that highlighted a few themes. The themes were virtual services, non-fungible tokens or NFTs, and also green technology related goods and services. We're going to talk about these general themes, and then we'll also mention some very specific additions that caused change in U.S. practice. As a reminder, all the changes that we're going to talk about have already been incorporated into the current version of the manual. So let's get right to virtual services. So, about a year and a half ago, back in December 2022, the USPTO presented a webinar on trademarks and newer technologies. And as part of that webinar, we talked about identification and classification of virtual goods. You know, the virtual sneakers or the virtual handbag that your avatar might carry around in the virtual world. So if you missed that webinar and you'd like to go back and listen, there is a link to it in the notes section of the slides. During the Q&A session for that earlier webinar, we got a question about U.S. practice for classification of virtual services. I explained that at the time, the NICE classification provided no guidance on point. And so as a result, USPTO was considering IDs and classification of virtual services on a case-by-case basis, but we were generally trying to stick with the NICE general remarks. Now, although the US had put together this case-by-case approach, we also recognized that other national offices were developing different and in some cases conflicting practices. This is something that we try to avoid because it can cause confusion and also inconvenience for international applicants and users of the Madrid Protocol. This led to the US making proposals to create rules to harmonize the practices for classifying virtual services. And as it turned out, the US was not the only one interested in promoting harmonization in this area. The US, France, Switzerland, and also WIPO all made proposals related to virtual services, and each office took a slightly different approach. To reconcile the differences, WIPO decided to create a questionnaire for the committee of experts to gauge which approach was most popular. The questionnaire asked particular questions and asked the pointed question of whether national offices accept virtual services in the same class as the real activity. So let me give you an example. So would the office accept haircutting services for avatars in class 44 because haircutting services in the real world are classified in class 44? This question generated a lot of discussion. So some offices wanted to classify virtual services in the same class as the real world counterpart. They wanted to do this for simplicity and ease of administration. But the majority of national offices disagreed. The majority agreed that the impact of the virtual services on the real world, it's got to be considered. It must be considered when classifying the virtual services. And so the committee got right to work on changing the NICE classification to implement the majority view. First, the committee incorporated the broad classification principle into the general remarks. They incorporated it specifically in the services paragraph, subparagraph D. It was amended to read, the means by which a service is rendered does not have any impact on the classification. However, this remark does not apply if the purpose or result of a service changes due to its means or place of delivery. This is the case, for example, when certain services are rendered in the virtual environment. So the committee created a rule that focused on the purpose or result of the virtual services. After incorporating that general principle, the committee adopted examples in the alphabetical list. So the first example is a virtual service that has the same purpose or result, whether it is rendered in the physical or virtual world. Banking at its most fundamental involves moving money between accounts, maybe in the form of deposits and payments. When the result is movement of real money, banking services are classified in Class 36 based on the NIS Class 36 heading. And this is true whether the activity is performed face-to-face with a bank teller, using a web-based or mobile application, or in the virtual world. These virtual services have the same result as their real-world counterpart, so they're all in Class 36. The committee also adopted an example of virtual services that have different results when rendered in the virtual world. The committee adopted simulated travel services provided in virtual environments for entertainment purposes in Class 41. So passenger transport and transport of travelers, those terms are in Class 39. They involve the movement of people from one physical location to another. But when the transport services are performed in a virtual environment, the result is different. There is no actual movement involved. It's just a simulation. So when we pop on our VR headsets and our avatars board a cruise ship and sail across the ocean to a desert island, any virtual transport services are most likely being provided just for our entertainment. Or maybe they serve an educational or cultural purpose so we can learn more about the wildlife or the language and customs of the people living on that desert island. The committee decided that these simulated travel services belong in Class 41 based on the mention of entertainment activities in the NIS Class 41 heading. And that brings us to our first practice tip of the hour. When you are evaluating virtual services for the purpose of classification, there are really two key questions. First, what is the nature of the service activity that is being rendered in the virtual environment? And next, what is the purpose or result of the activity? So here we should really take into account the impact of the activity on the real world. Does it change any circumstance in the real world? What is the benefit to the user? Is it entertaining and amusing, or is it something more than just for fun? So this tip comes from the new TMEP section on virtual services, which is linked at the bottom of the slide. So here's a couple more examples from the ID manual on these are examples of virtual services that have the same results whether they're delivered in the physical or virtual world. First, we have online retail clothing store services rendered in virtual environments. This ID is broadly worded to include any virtual means, including a virtual world. So some retail clothing stores have set up shop in the virtual world, and you or your avatar can browse and purchase clothing, and you can have that clothing delivered to your front door. You are getting the same benefit that you would as if you were shopping in person. Also, online medical consultations rendered in the virtual environment. You can meet with a doctor using a telemedicine software platform or even in the virtual world. The overall purpose is to evaluate a health condition and maybe discuss diagnosis or treatment options. The purpose is the same whether it takes place in the physical or virtual world. Now let's take a look at some examples that have results that are different when performed in the virtual world. We added these examples to the manual based on what we're seeing in trademark applications and also in the marketplace, and they're modeled on the example from the alphabetical list. First, here they are again, the simulated hair cutting services for avatars provided in virtual environments for entertainment purposes in Class 41. Haircutting services in the real world, like I said, they're in class 44, and that's based on the term beauty care for human beings in the NICE class 44 heading. But when your avatar gets a haircut, your hair stays the same. It might make you smile or even make you laugh out loud, but these virtual services have no impact on the real world. They're classified in class 41 as entertainment services. Likewise, the simulated restaurant services have a purpose or result that is different from the real world counterpart. As our German colleague famously said at the Committee of Experts meeting, my avatar can go to the restaurant and eat a hamburger, but I am still hungry. This all brings us to our second practice tip. When services rendered in the virtual world are simulations or just computer generated representations of a real world activity, and they have an impact that is different from the real world activity, these are typically for entertainment purposes. They are considered entertainment services in class 41. And these IDs must be carefully worded for accuracy. They need to indicate the nature of the activity, that the activity is a simulation, and that the services are rendered for entertainment purposes, if that would be accurate. Like I said, it almost always is. If it is, those services are in class 41. Now, this tip also comes from the new TMEP section on virtual services. Again, it's linked at the bottom of the slide. So now it's time for another knowledge check. This one is also a multiple choice question. And the question is, virtual services are classified according to what criteria? Is it A, the nature of the service activity, B, the purpose or result of the activity, or C, both? And now we can see the results coming in. Excellent. And C is dominating right now.
Mm-hmm.
And it looks like they're still coming in. Great. Thank you so much for taking the poll. That's right. The answer is C. And this was another easy question, but it's intended to reinforce these basic points. So I'll pass it back to you, Amy, on a high note.
Thanks, Mary. Okay. And thanks again for taking another poll. You, like I said, you didn't know that there would be tests, but yeah, we want to know if you're kind of understanding what it is what we're talking about with these virtual services and other like products. We're going to move on and talk about yet another area that was discussed at NICE this past year. You've heard about virtual services that Mary just told you about, and how the Committee of Experts been grappling with virtual services, with those goods and services in that virtual world. Likewise, for the past 2 years, a related hot topic has been non-fungible tokens, or NFTs. NFTs first appeared in the NICE alphabetical list last year in the 12-2023 edition. It was developed a bit more this year for the 12-2024 edition. But before we get there, let's first answer the question, for trademark identification purposes, what are NFTs? A non-fungible token is a unique digital identifier that cannot be copied, substituted, or subdivided, that is recorded on blockchain and is used to certify authenticity and ownership as of a specific digital asset and specific rights relating to that. This definition comes from Merriam-Webster Dictionary, and it is the definition we use. Now, the NICE Committee of Experts in May of 2022, okay, so this was 2 years ago, first faced NICE alphabetical list proposals involving NFTs. Again, that was 2 years ago. There were only a few proposals that year as the technology was still developing, people's understanding and comfort level with the technology was evolving, and ultimately, the Committee of Experts in 2022 accepted one entry, and that entry was effective January 1st, 2023. Basic number 090918. Downloadable digital files authenticated by NFTs. Again, the basic number 090918 is just the unique identifier assigned to each term in the alphabetical list. A few months after that, so this would be last May of 2023, the committee really delved into NFTs, calling back what we said about the NIS proposal process. Member countries, now follow along, member countries were proposing and commenting on proposals starting back in the fall of 2022 as they prepared for the NIS meeting in May of 2023. This is the version that became effective this past January of 2024. This was a really interesting year because the committee of experts were also dealing with digital assets and virtual goods, NFTs and the like, and how to treat them, how to characterize them, all within the parameters of the NIS agreement. That year, in 2023, there were about 70 different proposals, 70 different proposals dealing with this type of what we call emerging technology, goods and services. And about 24 of those, of that 70, about 24 related to NFTs alone. Specifically, proposals to make non-fungible tokens all by itself as goods. The committee of experts did not accept that particular proposal. There were a few NFT-related proposals from the United States, of course, but also some from France, from Switzerland, from the International Bureau, from the Netherlands, which is typically a pretty quiet member country, and quite a number of NFT proposals from Australia. In the end, 7 proposals that called out NFTs were accepted and took effect this past January 1st of 2024. There were 2 key developments in adopting these NFT entries this past year. First, the committee of experts moved toward making the different national offices require applicants in those particular countries to provide more detailed specification about the nature of the items being authenticated by NFTs. There is a basic number 090918. That was the one that was adopted. I told you was adopted in May of 2022 that was shown to be for downloadable digital files. That was amended in May 2023, that following year, from downloadable digital files to downloadable digital image files. And then you see basic number 090933 for downloadable digital music files. That was also added to provide further specification to the nature of the items being authenticated by NFTs. The United States, as you know, and as we've said, has a fairly high standard for specificity in our IDs. So it was really good to see other countries also moving to greater specificity that was more in line with what USPTO's practice is. The other significant development in terms of the NFTs, and I said there were 2, and the other one was to the NIS alphabetical list that was effective this past January, was the addition of an entry that recognizes that physical goods may be authenticated by NFTs, and such goods would be classified in the class of those physical goods. Okay, so that entry, this is slide 26 if you want to get there, that entry, clothing authenticated by NFTs, was added to the NIS alphabetical list in for class 25. Okay, so follow that again. The entry that recognizes that physical goods may be authenticated by NFTs, those goods would be classified in the class of the physical goods. Okay, so by analogy, handbags authenticated by NFTs would be in class 18 for those experienced, advanced NIS people that might know those classifications by heart. Jewelry authenticated by NFTs would be in class 14, and doll clothing authenticated by NFTs would be in class 28. 2 other NFT related entries that were accepted by the committee of experts for 2024 were for the minting of NFTs, downloadable software in class 9, which are goods, and providing online non-downloadable software in class 42, which of course are computer services. Finally, the last two of the 7 new NIST alphabetical list entries with NFTs are related to retail services and online marketplace services in class 35. Now note, the past couple slides that we've talked about feature alphabetical list entries, which include the wording non-fungible tokens, followed by the abbreviation NFTs, and you'll see those in square brackets. And it's important to remind you that not all terms in the NIST alphabetical list are acceptable by USPTO policies and may not specifically be included verbatim in our ID manual. We follow classification, but the wording itself may not necessarily be accepted verbatim in our ID manual. We said USPTO has high standards for specificity of the wording. For these NFT entries that we've been talking about, they are not acceptable by US standards because they contain the square brackets. The USPTO does not accept those square brackets in IDs. Essentially, it's a systems issue. Starting long, long ago, the USPTO has used square brackets in registrations to indicate those goods and services that have been deleted from the registration. Okay, time for another knowledge check. Don't you love that we're doing all these knowledge checks? I think it's great. Time for another one. Have you been paying attention? For this one, you got a 50-50 chance. So you're going to do great. You're going to do great. What do you say? Okay, so are NFTs considered goods in trade, yay or nay? Super simple question. Are they goods and services, yes or no? For trademark purposes, of course. Boy, the answers are coming in kind of all over the board. Here we go. Doing pretty good. So far, the yeses are winning by about by double. Okay. That is clipping in. All right, just a few more seconds, just a few more seconds. Okay. And we are going to close the polling. Ta-da! Okay. Wow. So we have 143 people answered no to yes on that one, that NFTs are considered goods, yes. About half that number, a little less than half that number, said no. Interesting. Okay. The answer is no. Do I hear a collective gasp? Not in the trademark world. NFTs are not themselves goods in trade. Again, for trademark purposes, under the NIST classification, NFTs are digital identifiers that are maintained on blockchain. And what they do, it's like a certificate of authenticity and ownership. It's like a claim check. That's one way to look at it. They are not the goods they represent. Aren't you glad you came to this webinar? Now you know that. They are not the goods they represent. Hopefully that one wasn't so much of a surprise to you. Okay. Okay, now we're on for the third practice tip. An ID that involves NFTs must specify the nature of the goods being authenticated by the NFTs or the services involving the NFTs using wording that is definite and limited to a single class. Makes sense, okay? Let's try to put that practice into use. Here are 2 new ID manual entries. Again, we're talking about now the USPTO ID manual, not the NIST alphabetical list, that illustrate the tip that I just gave you. The IDs, both of them, specify the nature of the goods being authenticated or the services involved with the NFTs using wording that is definite and limited to a single international class. Well done. Okay, that covers NFTs, at least for this year. Now let's go on and talk about green technology. So another source of proposals that received a lot of attention in the NIST 12 2024 edition were additions to the alphabetical list related to climate change and green technology or green tech, right? As trademark attorneys, you all know that trademark practice often reflects not only what's happening in the marketplace, but often what's happening in society as well. And we are seeing growing concerns about climate change at the committee of experts level and some ingenuity in trying to respond to climate change. We're seeing that around the world. For example, In the NEAS alphabetical list, among the new additions is hydrogen fuel in class 4. This was proposed by Saudi Arabia. Hydrogen fuel is a zero carbon fuel burnt with oxygen. The next two additions that you see on the slide were from Japan, and they relate to solar energy. Very simple entries: mounting frames of metal for solar panels in class 6, mounting frames not of metal for solar panels in class 19. We have two new green tech entries in class 40. First, proposed by the United Kingdom, we have production of renewable green energy. Again, this is a reflection of the changes in the industry being responsive to climate change. And the second one is from Norway. We now have in class 40 carbon capture. This service activity provides the removal of carbon or the capture of carbon from manufacturing or different types of manufacturing plants. Moving on from Japan, we now have the addition of light emitting diodes, LED light bulbs in class 11. And finally, proposed by our friends from down under in Australia, the alphabetical list has plant-based imitation meat in class 29. Yum. And those are what we call green tech additions to the NEAS alphabetical list this year. Now, Mary will share with you some interesting changes to existing alphabetical list terms.
As Amy mentioned, I'm going to mention just 3 new additions that caused change in U.S. classification practice. So I'll be the first to admit that these examples are uncommon, and they may not come up in your own practice. So the reason I wanted to mention them is to reinforce points that we've already made about the NEAS classification, the committee of experts process for amending it, and our obligation to apply it. So the first item is eyelash separators. So prior to January 1 of this year, eyelash separators did not appear in any part of the NEAS classification. The USPTO filled in the gap in guidance all the way back in June 2001 when we added that term to the ID manual in class 8. And we added it in class 8 by analogy to eyelash curlers, which is in the NEAS alphabetical list in class 8. As part of our work reviewing Section 66A applications, we saw that the U.S. practice conflicted with other national offices that were classifying these goods in Class 21 as cosmetic utensils. That's a term that appears in the NEAS Class 21 explanatory note. So we think that these goods could be justified in either class, and we wanted to resolve the conflict. So we proposed adding them to the alphabetical list to harmonize practices. The committee adopted the term in class 21, and we implemented the change effective January 1 of this year. And the next example is bra extenders or bra strap extenders. So again, the goods are maybe uncommon. So for both of these goods, we wanted to give you an image there of these goods. So with these goods, it's a similar story. Without specific guidance in the NEAS classification, these goods were listed in the manual in class 25 because we considered them to be parts of clothing, which is a term that appears in the class 25 explanatory note. We made a proposal to add these goods to the alphabetical list to harmonize practices, and the committee adopted bra extenders in class 26 by analogy to other clothing related goods that appear in the alphabetical list in class 26. We adopted this change, noting that it also impacted the vest extenders and the waistband extenders. So we moved those goods as well in the manual. So the last item I wanted to mention is restoration of printed photographs. Prior to January 1, the ID manual included restoration of photographs in class 40, based on the understanding that the process involved a change in the object's essential properties. That's wording that's directly from the NEAS class 40 explanatory note. The committee adopted a proposal to add restoration of printed photographs in Class 37 by analogy to restoration of works of art, which is in the NICE alphabetical list in Class 37. We adopted that change, and we also added digital restoration of photographic images in Class 42. So I mentioned that because I wanted to highlight that restoration of photographs would no longer be acceptable under NICE 12 2024. That wording would be considered overbroad. We require you to specify the type of photograph for classification purposes in either Class 37 or Class 42. Amy?
Here we go. Mary just talked about some changes to classification to existing US ID manual entries due to the decisions made at the NICE meeting. But there were also a few amendments to some entries in the NICE alphabetical list that require greater specificity in order to be properly classified. Nails, previously in Class 6, must now specify metal nails to be in Class 6. Alternatively, non-metal nails, those would be ones of plastic or possibly made of a polymer composite, those are now in Class 20. Another one, elastic bandages, previously in Class 10, must now distinguish between how and why they're being used. For example, a commonly misused trademark registration is for Band-Aid, Band-Aid brand bandages, right? Those bandages are used for dressing, so they are in Class 5. If not used for dressing, another commonly misused trademark registration is for ACE bandages. Yes, ACE is a registered trademark. Those types of elastic wrap bandages are in Class 10. Finally, frying pans, previously in Class 21, must now specify their mode of operation. Specifically for classification purposes, you must specify whether they are electric, those are in Class 11, or whether they are non-electric. Those are still in Class 21. We're on the home stretch. Mary?
Right. Yes, we are absolutely in the home stretch. Thank you, Amy. I'm going to switch gears a bit now and talk about rental services because there were a number of rental services added to the NICE alphabetical list under NICE 12 2024. And unlike eyelash separators, you may encounter rental services in your own practice every once in a while. So here are some examples of the terms that were added under NICE 12 2024. This list is not exhaustive, just some examples. So first, rental of pastures. It was added in Class 36 by analogy to rental of real estate in Class 36. Rental of scientific microscopes was added in Class 42 because they are used for scientific research activities, which are also in Class 42. The rental of surgical microscopes was added in Class 44 because those are used for surgery, which is considered a medical service in Class 44. And the rental of eyeglasses was added in Class 44 because medical equipment rental is in the alphabetical list in Class 44. And the committee just presumed that the eyeglasses are prescription eyeglasses. So I wanted to bring up this topic because rental services can be tricky when it comes to classification. So this brings us to our final practice tip. The general remarks gives what appears to be a clear rule, which is that rental services are classified in the same class as the services provided by means of the rented object. So to keep this straight in my mind, I like to think of simple examples. Telephones are means for using telecommunication services. So the rental of telephones is in 38 with the telecommunication services. Cars are means for transport services. So the rental of cars is in Class 39 with the transportation services. Thinking of these examples, it seems so easy, but classification of rental services can very quickly become complicated. So let's go back to that previous slide. A pasture is defined in the dictionary as a plot of land used for grazing animals, and rental of pastures is classified in class 36. So does that mean that this new alphabetical list term refers to rental of pastures for grazing animals and other agricultural purposes? Or would rental of pastures for other purposes also be in class 36? What about rental of pastures for a limited use, like for a county fair or a wedding ceremony? What would be the best class in that case? Also, rental of eyeglasses was added in 44 based on the presumption that the eyeglasses are prescription eyeglasses. But what about rental of just the frames, non-prescription eyeglasses for fashion purposes? Would those also be in class 41, or would they be in 45 by analogy to clothing rental in class 45? So under NEAS 12 2024, these are unanswered questions. And these are examples of the questions that we consider when we implement the changes under the NEAS classification each year. This is also the reason why, after many, many years in this job, Amy and I still find it interesting and challenging. So Amy, today we've really only scratched the surface of all the changes to the ID manual under the current version of the NEAS classification. But how can I see the changes to the manual, all the changes made to the manual effective January 1 under NEAS 12, 2024?
I am so glad you asked that question, Mary. I will show you how to do that. Yes, there is a way. As we've said a number of times that there were about 500 proposals at the NEAS level and about 350 changes that were effective January 1st of 2024. We've only talked about some of them, but these changes impacted over 800 entries in the USID manual just this year alone. So you want to see how you check that out? Go to the ID manual on the USPTO website. Dun, 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 dun. Go to the ID manual. Okay, so there it is on your screen. Up to the upper left, you see the magnifying glass icon. If you hover over it, you can see toggle advanced search criteria. Click on that. And then you scroll to the bottom and you see effective date. It's the very last drop down at the bottom. Hit the drop down, hit equals, the one at the bottom, and then it'll pop up a date possibility. Go ahead and put in January 1st, 2024, or whatever date you want. Today we're talking about January 1st, 2024. Click search, and then you'll see that there were 835 records that were deleted, added, or modified effective this past January 1st. Specifically, if you look further, you'd find that 645 were added, 183 were deleted, and 7 were modified. Now, let's say you just want to find the ones that were just added. That's all you're interested in. So go back over to the left side navigation. You see the status? Click unclick everything except for A, added. Just unclick all those. Okay, so now you're just going to find that we're added. Again, effective January 1st, 2024. Hit search. And you'll see those 645 entries that were added just this past January. Now, if you want to organize your search a little bit, you can go up, and this is what we do in ID class, sort by, say, class. So they'll put them in classification order. And then we often use description. That will put the search results in alphabetical order, so it will be by class and alpha order within each class. Easy. Okay, we have covered a lot in this webinar, but as Mary said, we've really only scratched the surface of some of the changes that happen at NEAS, and not just this year, but every year. Sometimes there are genuinely new things that are presented at NEAS. Some proposals may be very subtle. Some may even seem trivial. Maybe others are more significant. But once the proposals have gone through the whole process and have reached the committee of expert level, all of them are considered. And today we clarified how to identify and classify virtual services based on the NIST classification. We have many new entries in our ID manual addressing NFTs, which are not goods in trade. As a result of the 7 new alphabetical list entries involving NFTs, there's a global movement in the green tech field, and NIST 12 2024 reflects some of that movement. And finally, we presented various changes to classifications as well as clarifications needing for existing ID alphabetical list terms. So, Mary, can you remind us of the key takeaways?
Yes, thank you. That's a great idea. So let's take one last look. If you remember only one thing from this webinar, we want it to be this. The NIST classification is a guide for classification only. Also, it's mandatory. And what that means is when the classification is clear and unambiguous, the USPTO is required to apply it, as are the other 90 plus members of who have signed on to the NIST agreement. So finally, the guidance is incorporated into the manual. We incorporate the class into the manual to take out the guesswork for you and the applicants that you represent. So we hope this webinar gave you additional insight as well. And so we want to close with a final poll question. And this one gives us insight on the usefulness of this topic and the way that it was presented. There are hundreds of changes made to the manual each year as a result of changes made to the NIST classification annually. But this might be the first time that we presented it for experienced practitioners outside of the USPTO. So the question is, should we do it again? Would you attend annual USPTO webinars on changes under the NIST classification? And I am very excited to see the results of this poll.
Would it help if we said that these answers are anonymous? Your poll, it's anonymous, so we don't know who you are, but it's very encouraging, Mary, to see that people may
Yes,
be interested in the NIES
absolutely.
classification. We're not the only ones. Hooray!
Right.
Other people are interested in the NIES classification.
Okay, well, as this continues to roll in, I'm going to thank everyone for taking the poll. Thank you for attending. Thanks for your patience as we worked through a few technical issues. I'll hand it back to Marisa for the Q&A session.
Thank you, Attorney Kelly and Attorney Munson-Ott, for your informative and, dare I say, lively discussion on trademark identification and classification practice in the United States. I mean, it is staggering to think that over 800 entries in our ID manual have been affected based on changes to the NIST classification since January 2024. Did I get that right? Yes. Okay. Wow, that is a lot. So thank you for ushering us through that and showing us where we can find this additional information. So let's go ahead and shift. Let's shift to our Q&A portion of today's program. And I want to start it off with just a couple of good questions. I'm looking at the clock, so I know that we don't have a ton of time, but let's just go ahead and start. So our first question relates really to virtual worlds. Now, you talked about virtual environments and virtual worlds like Second Life. But it seems like this is just the metaverse. Now, this is a question for Mary, so here it goes. Why don't any of the new IDs say metaverse?
Yes, so good catch, Marisa, or I'm guessing that came in through the chat. So
Mhm.
good catch, you're right. The term metaverse does not appear in the ID manual, and that's because the term metaverse is a registered mark in the US. So I think it's registered for software as a service, platform as a service, and maybe even providing online games. So the terms in the manual, those are supposed to be acceptable without any question or further inquiry from the examining attorney. So when the examining attorney sees the ID, the examining attorney should be able to accept it without issuing an office action and requiring any clarification. So over the past few years, some national offices have made proposals to add terms to the NICE alphabetical list that include the term metaverse, because like I said, it's registered in the US, and I believe it may be registered in maybe at least one other country, but it's not registered, it doesn't prohibit use from other international applications. So, like I said, there have been proposals that included the term metaverse and adding terms for goods and services to the alphabetical list that include the term metaverse. But other national offices have also used virtual environment or virtual world. And the committee of experts actually considered the advantages and the disadvantages of using multiple terms that may or may not be interchangeable, or picking a preferred term that would be used for consistency. So the committee discussed this, as I said, and ultimately picked the term virtual environment as the preferred term because that term is the broadest. It's so broad, it could include any web-based or software-based setting, and it also includes the virtual worlds like the Second Life and the Sandbox. So when virtual services are simulations of real world activities, like it's just a computer generated representation, it is likely that that virtual service takes place in the virtual world. And the ID can indicate that detail. We do have terms in the ID manual, not only that mention the virtual environment, but also mention the virtual world. But the entries in the ID manual, like I said, don't include the term metaverse. So keep in mind that metaverse is a registered mark, and when it appears in a trademark application, the examining attorney will generally follow up and ask questions about the term to make sure that use of that term is the generic use.
Thank you. That's very helpful. I know that we always have to be concerned about using other folks' registered marks in our identifications, and that's just a nice reminder of why we don't use metaverse. Okay, very great. What about this one for you, Amy? Okay, what happens if I filed an application in, say, October 23, then NICE 2024 took effect on January 1st, 2024. But now I want my ID in my October 2023 application to use the NICE guidance that happened after I filed. Are you following me? In January 2024? So maybe you restate that again. But I'm trying to, I guess they're trying to figure out what is going to happen if there's a change midstream.
Absolutely. And this is a great question. And of course, it happens every year because we update the manual January 1st of the year based on the changes to NICE. And sometimes that can have direct implications to IDs in applications pending examination and applications that are in the midst of examination.
Right.
And actually, it's addressed in the TMEP. So those of you that are interested or ask that question, you can check out TMEP section 1401. 1401.09. And again, the question is, what happens when you've got an application you've already filed, NICE happens January 1st, and does that impact your ID? And it can. This applies only to applications that were filed under Section 1, so intent to use or use applications, or those filed under Section 44, so based on a foreign application or a foreign registration. For those types of applications, sections 1 or 44, if you file it after January 1st of this year, and I'm going to go ahead and assume we're talking about the 2024 edition, but this applies every January. If you file it after January, then the application, the ID in your application must comply with that edition of NICE, in this case 12-2024. If you file the application before January 1st, but it isn't examined. It's still, it's in the pendency period. It hasn't examined until after January 1st. The applicant may choose to amend their ID relevant to the changes effective 12/2024, right? Okay, so let's say you have an application, it's going through the application process, and you're amending it. So you're in the process of amending your ID, and so it was filed and initially examined prior to January, and the applicant's ID complies with the NIS before, but now you want it to comply with 12/24. What do you do then? Any outstanding requirements to amend the identification that complied prior to that NIS edition may be withdrawn, because you have the right to comply with the NIS edition of that time. The ID or classification then may be accepted based on the compliance for NIS 12/2024. It gets kind of wonky, and your examiner can help you through this. So if you're sounding confused, your examiner can help you through that. There are two caveats here. Again, what I said before, this does not apply to Madrid protocol applications, section 66 applications. This is only for those filed under sections 1 and 44. Also, in applications where the applicant has complying with either an earlier edition of NIS or the current edition of NIS, the entire ID must comply with that edition of NIS. It's not okay for some classes to say follow NIS 12/2023 and other classes to follow NIS 12/2024. The whole thing has to be compliant. Again, if this is making kind of buzz in your brain a little bit, you can check out TMEP section 140109, and your examiner can help you walk you through all that.
Thank you. I vaguely remember this as I was examining and how I had to review that information because, yeah, it's
Every
not
year.
necessarily intuitive. You need to stay on top of those changes and those rules you mentioned. But thanks for clarifying that that does not really apply to our Madrid applications and for reinforcing section 1401.09 of the TMEP to help us. Okay, Mary, this is back to you. All right, so here's a question from our experienced practitioner who's attending today. My clients always want to know why the USPTO requires so much specificity, even more specificity maybe than other countries, right? Can you provide some additional context, some details? Why is this the case? Or is it the case? Okay.
Well, as Amy mentioned, the USPTO does have very high standards for specificity. And, we keep coming back to that general rule in the TMEP that IDs must be specific, definite, clear, and accurate. So we know that's the rule, but, really the question is why? And we get this question internally. We get it from the outside, and it really is a good reminder, even in ID class. It is a good reminder. We keep going back to, the policy reasons. Why so much specificity? And we consider the why when we go back to existing specificity requirements and reanalyze and reconsider them to determine whether they're still needed. So I think that for the question of why, there are a couple really basic reasons. So the first one is because specific IDs provide public notice. So when you file your trademark application, you are putting third parties on notice of the scope of your claim to trademark rights. So that's just a kind of a fundamental reason. So in the case of new technology, so we require common commercial names, right, or generic terms. In the case of new technology, we require specific details when the technology is so new that it may not be widely recognized or commonly understood. So the specific explanations help third parties understand the nature of goods or services. So the example I always think of is, the home automation hubs. So when we first added that technology to the ID manual, it was a very long, detailed ID in the manual because at the time it didn't there was not enough evidence in the marketplace to make us feel comfortable that that home automation hubs was widely recognized and commonly understood. Now, I think most of us probably have them in our homes, and they're certainly in the newer construction, the homes that are being built. So that would be the first reason. So you know, and then I keep hammering this point. Specific IDs really help examining attorneys thoroughly examine the mark, and they help examiners and third parties make likelihood of confusion determinations. So when we think about specificity requirements, you know, sometimes very shorthand will say 2D requirements, requirements that enable examiners to make those close calls, really, because very often likelihood of confusion decisions, they can be close calls. But I think really the overarching reason relates to USPTO's mission. So USPTO's mission is to register trademarks, and specific IDs promote registration and help us fulfill that mission to register trademarks. So let's think back to that example about publications. I gave that example to explain the specificity requirements for classification purposes and how we build on top of, you know, that basic requirement to limit the ID to a single class, and we require even more specificity. So I think that example, it really tells us a lot about the nature of the publications industry. Why do we require so much specificity for publications? And I think it's because it's a crowded field. So there are many publications that are all competing for your eyes, all competing for your readership. And these specific IDs allow similar marks to potentially coexist on the register when the IDs make clear that the goods or services are not related and there's no likelihood of confusion. And that's the way that specific IDs really promote registration and really help the USPTO fulfill its mission.
Very helpful. It's definitely nice to get a better understanding of the policy behind all of this. So thank you very much for that. Well, that's why I love trademarks, because we're on the cutting edge, right? Things are changing and we're adapting to address it. Okay, let's how about this question for you, Amy? We're going to jump back to this conversation about NFTs. And so the query is, with NFTs, is it safe to assume that I can use any good listed in the ID manual? I think I already know where this is headed. I can use any goods in the ID manual and just add, quote, authenticated by non-fungible tokens to it, and it's going to be acceptable in the same class as the original goods. What do you think about this approach?
Oh, that's a really good question, because we talked about how, you know, clothing authenticated by NFTs are in 25, handbags authenticated are in 18, and all that. But you said, is it safe to assume? We're lawyers. It's not safe to assume
Not ever.
anything. So first of all, never safe to assume. That would be the first thing I'd say. But let me do the nut of the question. Based on the information we have right now and the current guidance underneath, it appears that the direction would be to permit goods authenticated by non-fungible tokens and still remain in the class of those goods. So that's certainly the direction we're going. Eyeglasses, for example, are in class 9. Eyeglasses authenticated by NFTs would still be in class 9. However, in our ID manual, there's over 60,000 entries, you know, 10,000 at the NICE level, 60,000 in our entries. There's lots and lots of goods and services in the ID manual. And so until there's additional guidance, case law, more guidance from NICE, from the Committee of Experts, I'm not sure we could say for certain that it would work for all goods every time, but it appears that's the direction it's going. So depends. Isn't that wonderful? As a lawyer, you'd say, well, it depends, but it looks like it's going that way. Jury's still out.
Okay. Okay. Well, we like that answer. You need our help. So yes, we're standing by. Okay. I'm looking at the clock. I just want to hit maybe one or two more, and then we're going to go ahead and close out for the day. We want to respect everyone's time. But here's a question, and I kind of wanted to try to figure out who to give the question to, but I'm looking at your faces now. You're going to have to help me with these coming up. Here's the question. As a practice pointer, before the USPTO, are we supposed to look at these classifications or refer simply and only to the USPTO's Trademark Identification Manual of Goods and Services? What do you think? Should we be toggling between both to try to better
Oh,
understand
I
what?
know, Mary. I think we both can answer. Mary, I know
Okay.
you'll be very articulate on this one.
Mary, you want to try? Go ahead, please.
Well, as we both mentioned, the exact wording of the NICE alphabetical list terms is most of the time too broad under USPTO's specificity requirements. And at the same time, the wording that's in the ID manual, we have analyzed that wording, we have reviewed it, we have incorporated it into the manual, and we have also assigned it a classification. And if that wording that appears in the trademark application is acceptable as of the filing date, the office accepts it without further inquiry. So while the NICE classification can provide guidance, if you have if you're dealing with goods or services that don't appear in the ID manual, and you would like to refer to the NICE classification to try to get a better understanding of what class or classes it could be, the NICE classification is a great resource for that analysis. But in terms of preparing trademark applications in the US, please refer to the USID manual, and please use TEAS Plus. Please adopt an ID from the manual if you determine that it's accurate, and then we will accept the ID and the assigned classification, the designated classification, without further inquiry.
Okay, so you can trust the identification manual, right? We can trust what's in there.
As of the filing date, yes, we can.
Got
Yes,
it.
we can.
All right, very good. Okay, so last question. Uh, what about if you just want to check if an identification is acceptable the day you're working on? Okay, you're just curious as to what is going on the day you're working. Can you pick a specific date in the ID manual? We saw how you selected a date when you were on the WIPO page. Can you do that for the ID manual?
It's picking an effective date for when to see. Yeah, absolutely. You can pick a date, but you won't always get results because the ID manual is updated January 1st every single year based on changes made at the NICE Committee of Experts, right? Other than that, the ID manual is updated every single week on Thursday. It's updated every Thursday. So if what is it today? This Thursday is the 27th. So it'll be updated June 27th. So if you put in June 25th of 2024, you're not going to get any hits because nothing was updated, nothing was effective of that date. But the effective dates are going to be January 1st, excuse me, January 1st and Thursdays.
Fascinating.
Mm-hmm.
I didn't even know that. Okay, thank you for
There you
sharing
go.
that
Aren't you
information.
glad you came to this webinar?
Yes, I
Yeah.
am thrilled. Okay, so we're going to go ahead and close out. Thank you so much, Attorney Mary Munson-Ott and Attorney Amy Kelly, for this wonderful presentation today. It was really thoroughly interesting to all of us. So thank you very much. I want to thank you for the folks who are helping out in the background. We have some other leads and experts in the background who have been assisting today. Thank you so much. Of course, my manager, Jason Lott, is always here to assist, and he's been helpful today. We want to thank him. He is the managing attorney for the Trademarks Customer Outreach Office. So thanks, Jason. I want to also draw your attention to a few reminders before we close out today. Around 3:30 p.m., Eastern Time today, you're going to receive an email that contains a link to the following, a link to our survey. I promise it'll only take you 3 to 4 minutes to complete. Please let us know how we're doing. We want to hear your feedback. We always try to make adjustments based on what you say. You're also going to find a link to our presentation slides and a handout that we have that we think will also provide some additional information. We're going to post our recording to this webinar in 2 places, on USPTO.gov and also on YouTube in about 3 weeks or so. So stand by for that. And finally, absolutely, we have been approved for 1.5 hours of CLE credit in Virginia. So we're going to be sure to forward that CLE documentation to our attendee list for today. That documentation is going to include instructions on how you can apply for CLE credit outside of Virginia as well. My name is Marisa Terrell. Thank you so much for joining us today, and visit our webpage for more information on the next webinar. This is www.uspto.gov. Type events in the search bar and you will find us. Thanks so much. Have a great day.